Equity or chancery law started as the law of conscience. Chancellors resolved each dispute by asking what justice demanded. This was the very attraction of early chancery law, because the common law had become extraordinarily complicated and bound up by rigid precedent. One criticism of chancery law was that the decisions made by the chancellors might be arbitrary. A legal author named John Selden wrote that equity depended on the length of the chancellor's foot. A clever way of saying that equity really did just depend on the views of the judge of the day. During the 17th century, this began to change as judges in equity began to look more and more to precedent. Precedent didn't operate in the same way as in the common law. It wasn't quite as binding, but reference to prior cases did iron out the tendency to have arbitrary decision-making. This particular case was apparently notorious at the time it was heard because it took years to resolve. The facts are actually quite mundane. It was a battle about whether certain leaseholds were held absolutely or held on trust by an executor for the benefit of a beneficiary, and also what rents were due in relation to that land and to whom they were due. No doubt matters of extreme importance to the participants in the case, but perhaps less important to us. The case is remembered because of the way in which Lord Nottingham went about his judgment. It's interesting because when you read the judgment, much of it is actually him exercising his own discretion about the evidence he finds convincing and the quality of the witnesses. But on the law, he is clearly seeking to make this judgment consistent with judgments of the past. Lord Nottingham said, "With such a conscience as is only naturalis et interna, this court has nothing to do. The conscience by which I am to proceed is merely civilis et politica, and tied to certain measures, and it is infinitely better for the public that a trust, security, or agreement which is wholly secret should miscarry, than that men should lose their estates by the mere fancy and imagination of a chancellor." This case is remembered for this passage, which presents equity as a growing body of actual law, and not merely the individual views of chancellors and judges.